All right, here we
Thanks.
go. Hi, Adam Mills here with Roy LePage, and welcome to our Facebook Live series, Divorce Isn't a Bad Word, Navigating Uncoupling. Over the last year and a half, we've seen as a team and a brokerage just how much of a toll COVID's played on people's relationships. And as a result, we wanted to put together a Facebook Live series. So there's 6 different pieces of this where I'm going to be talking with other industry experts. And the goal of this is to create a library or a resource for those going through the uncoupling process. So super excited about today's show. So we have James Jeffcott here, who is a partner and a lawyer at Lowe, Murchison and Radnoff. And the topic of today's show is the family home. Don't sell until you have this, which is kind of a fun little hook. And in terms of just giving you a sense of who James is, or as I know him, Jim, I'll read out a quick introduction on him, and then we'll get right into it. Called to the bar in 1990, James Jeffcott is an OACP Collaborative Professional and past president board member of Collaborative Divorce Ottawa. He is the head of family law division at the Lowe, Murchison Radnoff firm, where he focuses on the non-adversarial process, so helping people find resolutions without going to court. As a trained mediator, James knows it is in the best interest of all parties involved to get away from the win-loss mentality, which is the court process. Instead, he's passionate about working towards a resolution that works for everybody. So, James, again, thank you so much for making the time. I know you're a very busy guy, so I appreciate you making the time to be here today.
It's a pleasure. It's a pleasure. So yes, and of course, yeah, most people call me Jim, as you indicate. So we'll stick with the less formal for sure. But I sign all my correspondence, Jake, for sure. So.
Gotcha. Sounds good. So one of the things, I guess, obviously the topic of this entire thing is, something that you absolutely need, before you go through, it could be selling or it could be transferring the ownership to of the matrimonial home. I know we're gonna get into that, a lot deeper a little bit later. But something I wanted to just throw at you was, you had a few things to, for people to consider, that kind of surrounds, the matrimonial home, or it could be the transfer, the sale, like I say. One of them were, issues for parenting, and there's a few others that you kind of had in there too. So maybe you could kind of elaborate for us a little bit on, like, what are the primary things to consider for people right now?
Yeah, so most people think that that's a pretty simple exercise, right? You deal with the matrimonial home, and of course, when I say matrimonial home in this context, I'm talking about a house that is the residence for married spouses. But of course, it could also apply to unmarried spouses, but different rules apply because the marriage, of course, provides certain rights and entitlements that non-marriage doesn't. So when we say, I guess we're going to use interchangeably the word matrimonial home, or we might call it family residence. But there's lots of considerations. It's not as simple as just, okay, we're going to sell it, or okay, we're going to transfer it from one spouse to the other. There's a lot more implications. And you pointed out, for example, the issue with regard to if there are children residing in the home, then is it appropriate, right, to dispose of the home at a particular time? What does that mean for time sharing? What does that mean for decision making for the children in terms of, where are they going to go to school? Can the buses pick them up? Those kinds of issues. Have they got a relationship with neighbors and with their community, and where do they play their sports and those kinds of things. So this is a consideration,
Right.
That a court, if they were looking at this, would have if they're thinking about whether they're going to agree or disagree with the idea that the property should be disposed of or transferred, right? So that's one thing. And of course, the other thing is that it has implications for the division of property. So the value of the house is included in whatever calculation, but it's not just about whether or not the value is included, but it's also about what's the resolution at the end of the day. So in our process in Ontario, we don't divide things, we divide value. So when we calculate entitlements to division of property, we're calculating values of things, and a house is just one of those things. And there are going to be other things like pensions and bank accounts and, shares in companies and insurance and, policies, that kind of thing. And so we add all that stuff up, we subtract debts, and that's a very simplistic way to talk about it. And then there's an amount that's owing from one to the other, depending on how the math works out. Now, again, this all applies to married spouses, not to unmarried spouses, which is a little different. And so then the question is, okay, so how are we paying for that, right? And so, go ahead.
Well, I was going to ask the other thing too was that popped in mind was, are there tax implications that also surround this kind of equation as you're going through it?
Yeah, that's definitely an issue. Of course, there's an exemption for primary residence, but there are some rules around that you have to meet in order to qualify for that exemption. When I say exemption in this case, I'm talking about exemption for capital gains, right? And so, for sure, that's going to be a consideration, and we have to make sure that we're following those rules when we, when we're deciding about what to do about the disposition of the house. I was going to go on to tell you about the fact that, so when this transaction, whatever it's going to be, whether it's a transfer or a purchase, by a third party, what happens to the money? So, when the transaction closes, encumbrances like mortgages and liens and stuff are going to get paid out, as well as the real estate agent's fees. You'll be happy to hear that. The lawyer's fees, right? And then with some adjustments. But then, for what's left, typically that money, if there's no resolution about what happens to the property, and sometimes if support remains an issue, that money needs to be held in trust. So the money's not available to the parties until these other things are resolved. Which brings you to the point that I think you were trying to get at the beginning, right? Which is you must have a separation agreement, right? It's absolutely key, right, that there's a separation agreement in place prior to the transaction happening. And there's lots of implications about that, that we need to think about. So often we find ourselves in situations where parties have already made these decisions before they've got advice, or before they've resolved things, and then we're into a much more complicated problem, right, in terms of disposing of this property, right? So we have to think about really saying to people, the first thing you have to have on your plate when you're thinking about what to do with the house is, do we have a separation agreement or not? It's going to have an impact on financing. It's going to have an impact on what happens to those funds. It's going to have an impact on, as you say, the tax issue, right? And to the extent that people don't have that resolved, it really does create challenges for professionals and for the parties to come to resolution when they were already under the gun, if you like, under the being forced to meet an obligation to a third party, and it's a third party, perhaps like a purchaser, right? Because the purchaser wants the house, right, on the day that they contracted to get it. Yeah. And if you don't have an agreement, then you can't get your financing because you don't have a separation agreement, right? I mean, you can tell us about that. You've been through this, I'm sure, Adam, where your deals are running into problems with getting money.
Yeah, a number of times where, I mean, if we're working with someone who's selling, the first thing I say to them is, do you have a separation agreement? If they say no, I say, okay, well, you need to talk to your lawyer, or mediator, or you need a legal professional, because the thing is, you need that piece. Otherwise, like you were saying, you can sell a house, that's fine, but money's not going anywhere. It's going to get stuck in trust, get stuck in limbo. And it also, it creates undue stress on an already stressful situation. Because now everyone's rushing to try and get this separation agreement lined up, which could have implications to do with children and a bunch of other things. And to me, it's not a piece that you necessarily want to rush through. I think you want to think through it in a systematic way and just make sure that everyone involved is being properly cared for, and not being stressed about going, oh, well, God, my closing date is 30 days out. I need to get this thing done in 30 days. Right. So, it's certainly, it's something that needs to be thought through. And on the buying side, you can't get a mortgage from, it could be a bank or broker, it doesn't matter, until you have a separation agreement in your hands.
Right. Yeah, I mean, so often we find ourselves in negotiations, and of course, the parties who are in that situation really tie their hands in terms of the options available for them, as far as what the outcomes might look like if they've got this obligation hanging over their head, to try and ensure that a closing happens in a time frame that maybe not be realistic, right? Because there's a lot of work that goes into doing a separation agreement. It's not as simple as one might think, and of course, you and I talked, recently, and I basically said, look, this is not something you want to do at a kitchen table, right? This is not a situation where you want to be trying to work this out between yourselves without advice. Really is a situation where advice is necessary, and it's not just advice of lawyers, but also accountants and real estate professionals like yourself. Maybe appraisers are necessary. There's a whole sort of series of issues that relate to this. So so whatever process you're in, and I'll talk to you a little bit about process in a minute, but whatever process you're in, time is really your friend, but not having time is not, right? So you can really get yourself into a bind in terms of what you can accomplish, right? If you're facing deadlines, right? So.
Yeah, no, it's exactly. I mean, I think it's one of those things that you need to take the appropriate time. You need to, make sure you're, as I said, going through it in a systematic way, and not just rushing to say, okay, well, list the house, let's sell the house, let's move on. And a lot of, not to point fingers, but a lot of realtors who maybe aren't experienced in the kind of uncoupling world, they get a phone call from someone saying, oh, I want to sell my home. They get excited, they show up and they put a for sale sign on the lawn and they move on. But if you don't ask the right questions, you're really not doing anyone involved in this process a favor, because the sellers won't achieve their goal because the money just, again, will be stuck. And whoever buys that house will also not be that pleased if it doesn't close because there's other issues at play. So it's really about slowing down and saying, okay, well, let's make sure we're navigating this in a systematic or logical, manner.
Exactly. Well, it's
One
good
thing
for our
that
civil litigators, right? This,
well, one thing that I know we talked about a little while back was just the way you go about things. So I mean, you're unique, I guess, in the sense of saying it's non-adversarial, collaborative. You're not interested in going into the courtroom and putting on boxing gloves. So maybe you can kind of help explain that piece and how that aspect works.
yeah, that's by all means. And I don't, I don't want to say that there's never a situation where court is appropriate, because there are situations. We just prefer to avoid it. It's really not a great place to resolve these kinds of issues from my perspective, but we appreciate that sometimes it's necessary, and so it's there, to use it. But my focus is on making court the alternative, as opposed to what when we talk about alternative dispute resolution, in nomenclature now, people think of, the mediation and collaborative and those other processes. But I like to reverse that thinking and say, these alternatives, so-called, are actually the way to go. So let's talk about what those look like. So there's a few, so in terms of formal, we talked a minute ago that, trying to do this informally is really probably not a great plan. So in terms of formal negotiation processes, there's mediation. Right. And so in mediation, you have a single professional, not necessarily a lawyer, could be, there are non-lawyer professional who are mediators, who assist to people to reach resolution, draft agreements in some cases, and then, the folks take those agreements and have them reviewed by lawyers, to finalize it from a legal perspective. There's collaborative practice, which is, something that I prefer. Collaborative is a interest-based formal negotiation process. We agree in advance that we're not going to go to court. We agree that we're going to resolve the issues within that process, but we have an agreement that basically protects us and allows us to have conversations focused on interests as opposed to positions, and to resolve things in a way that works for the family. So we can look at more than just legal issues, when we're resolving that stuff. And another advantage of collaborative is that there's often a team. And so there's sometimes a family relations professional who helps with the emotional stuff and who helps with the parenting and that sort of stuff. And then there's a financial professional who helps gather that financial information, talk to the parties about their financial situation and can do some projections, run scenarios to look at what the outcome might be if we choose a particular outcome. So that's, those are non-adversarial, what we say, consensual process options. We can also do arbitration, and arbitration is basically just like private court, allows people to appoint their decision maker. But it's an expert typically, and there's some advantage in terms of time and efficiency, and then court process. Now, I can tell you anecdotally that the consensual process options really tend to be more quick, more efficient, and they're really focused on the individuals as opposed to these sort of rules that are set down by by legislatures years ago, right? So so I really favor having these discussions for one of those those consensual process options, and certainly I favor collaborative if it's appropriate, and in very few cases I would say it's not appropriate. So yeah, those, and that's often one of the first things on our list. What are we doing about the house, right?
Yeah. Well, no, that's a great rundown of like the primary options that people or avenues, if you want to call them that people can kind of go down. And yeah, I mean, to me, I think I would agree. I mean, from everything I've heard, and the more I learn by doing these Facebook Lives with other professionals, I mean, it seems to me like if collaborative is an opportunity or an option, based on the relationship, it's certainly the way to go, because you get this team of experts working all towards the same common goal, which tends to be, in my opinion, the best possible outcome for everyone. So why not try and have everyone move towards that kind of that better space.
Yeah, 100%. It's really good for relationships, whereas these other processes, the adversarial stuff really can be very hard on relationships because it is all about win-lose. And that's in a family context is really where you want to be, right? So and the other great advantage, of course, is cost. It sounds like it might be it might be expensive because you're talking with lots of professionals, but the reality is that it becomes a very efficient process, and you have the right professional doing the right job, right, at their cost, and not and you're not using lawyers as counselors, for example, or lawyers as tax advisors, which we really ought not to be doing. So of course we have some incidental information, but there are experts out there, and they're experts for a reason. So the really advantageous to have professional advice in the areas, which is why we work really closely, of course, with agents like yourself, Adam, and it's much appreciated when the agents have an understanding, right, about sort of the implications and the choices and the problems. So yeah, that's great, and you wrote the book, right? So that's
that's right. Well,
some information.
That's right. Yeah, no,
Right?
Yeah, no, that was the idea. I mean, with the book, I mean, it's not trying to play lawyer at all. It's just to give people a high level understanding of, what are your options you have to go down if you are going through an uncoupling, if you have to, dispose of the matrimonial home. Like, what does that look like? What does that feel like? So that was really the context of the book for sure.
Yeah.
Well, that's amazing. I don't want to take up too much more of your time, but I really appreciate it. I mean, I think, like for me, the takeaways here, at least in my opinion, are first and foremost, before you do really much of anything to do with the matrimonial home or going out to buy a new property, is make sure you have a separation agreement ironed out, signed, sealed, delivered, done. Don't rush through that because you have a timeline over your head because you sold your house. And the other thing is, if it's at all possible, navigating this in a collaborative fashion is certainly the best way to get the best possible outcome for everyone, and also by the sounds of it, save some money too.
You got it. Yeah, and make sure that we cover off those tax problems, like, before they become problems, right?
Yeah. Yeah, that's a good one as well. Well, excellent. Well, thank you so much. I really appreciate
Yeah.
it, and I'm sure we'll be seeing you soon too.
Hey,
All right,
listen,
we'll see you
thanks
later.
very much for giving me the opportunity. We'll talk soon. Take it easy.
Pleasure. Bye bye.